Imagine this. It's the dead of night. You're fast asleep in your own bed, in your own home, a place where you are supposed to be the most secure. Suddenly, the silence is shattered by the sound of your front door being splintered into pieces. A flashbang grenade detonates, blinding you with a searing white light and a deafening roar. Before you can even wipe the sleep from your eyes, you're being dragged onto the floor in handcuffs. You look up and you see FBI agents, the most powerful law enforcement in the country, holding your wife at gunpoint while your 7-year-old child cringes under the covers in the next room. Now, imagine the moment that follows. The agents look at a piece of mail on your coffee table. They look at their GPS. They realize they aren't at the house of a violent gang member. They are at your house. They got the wrong address. They apologize, hand you a business card, and walk out, leaving you with a broken door, a traumatized family, and a shattered sense of security. You do what any American would do. You seek accountability. You sue. But then comes the real kicker. The federal government looks you in the eye and says, "You can't sue us. We have immunity. In fact, even if we messed up, we were following federal policy, and the Constitution itself protects us from your lawsuit." That sounds like a dystopian novel, right? But it was the reality for Katrina Martin and her family in Atlanta, and it led to a case that went all the way to the highest court in the land. Today we are breaking down not one, but two massive 9-0 unanimous rulings from the Supreme Court that have sent shockwaves through federal law enforcement and have massive implications for every single gun owner in this country. These aren't just wins for individual families or specific cases. These are nationwide, fundamental shifts in how the government is held accountable when they overreach, when they kick down the wrong door, and when they try to turn law-abiding citizens into felons overnight. Before we dive into the gritty legal details, I want to ask you a favor. If you believe that no one, not even the federal government, should be above the law, please consider subscribing to the channel. We are pushing hard to reach 900,000 subscribers by the end of the year, and your support is what keeps this independent reporting alive. Also, double check that you're still subscribed. YouTube has a habit of removing people from Second Amendment related channels, so make sure that bell icon is active. Now, why does a 9-0 ruling matter so much? In a time where the Supreme Court is often portrayed as deeply divided, a unanimous decision is a legal earthquake. It means that from Justice Thomas to Justice Sotomayor, every single justice agreed on one thing. The way the lower courts were protecting the government was fundamentally wrong. When you see two 9-0 decisions in the same area of law within a short period, you're witnessing a complete repudiation of how federal agencies have been operating. This is the Supreme Court telling the government, "You've gone too far and we're drawing the line." Let me start with the first case, Martin v. United States, because this is where the nightmare becomes real. This all started in 2017 in a suburban area of Atlanta. FBI Special Agent Lawrence Guerra was leading a pre-dawn raid. They were looking for a suspected gang member named Joseph Riley. The target was 3741 Landau Lane, but instead of double-checking the street signs or the numbers on the mailboxes, the agent relied on his personal GPS device. The GPS took them to the wrong street. They stormed the home of Katrina Martin. They didn't just knock, they executed a full-scale tactical breach. Flashbangs, rifles, handcuffs, the whole 9 yards. When they realized the mistake, they left. But the damage was done. The physical damage to the home was one thing, but the psychological trauma to a 7-year-old child seeing his parents held at gunpoint by masked men is something you can't just apologize away. When the Martin family sued under the Federal Tort Claims Act, they ran into a legal brick wall. The Federal Tort Claims Act is the law that theoretically allows citizens to sue the government when federal employees act in ways that private citizens would be liable for, like battery, assault, or negligence. But the government argued they were protected by two things. First, the discretionary function exception, which essentially says the agent chose to use his GPS, and that choice is a discretionary government act, so you can't sue. Second, the Supremacy Clause defense. This was the 11th Circuit's special rule. They argued that because the FBI was carrying out a federal mission, state tort laws like Georgia's laws against assault couldn't be used to sue them. For years, the 11th Circuit, which covers Alabama, Florida, and Georgia, had a very strange way of looking at these cases. They actually gave plaintiffs a little bit of a win by saying they could sue for intentional torts, but then they balanced it by giving the government a massive shield called the Supremacy Clause defense. Essentially, the lower court said if the federal officer was doing his job and furthering federal policy, he's immune, even if he broke the law or kicked in the wrong door. The Supreme Court looked at that and said, absolutely not. Justice Gorsuch, in a sharp and clear opinion, pointed out that the Federal Tort Claims Act was written specifically to hold the government to the same standards as a private person. If a private security guard kicked in your door by mistake, he'd be in a world of trouble. The Supreme Court ruled that the government doesn't get a special supremacy clause shield just because they're the feds. This is huge, because for decades federal agents felt they were wearing a suit of armor. They felt that as long as they were on the job, they could be as reckless as they wanted with your Fourth Amendment rights. The Supreme Court just stripped a massive layer of that armor away. But here's what makes this even more critical for gun owners. You might be thinking, I'm a law-abiding gun owner. I don't plan on having the FBI at my door. But here is the reality. Wrong house raids are a nightmare scenario for the Second Amendment. When a no-knock or pre-dawn raid happens at the wrong house, and that homeowner is a law-abiding gun owner, what is their first instinct? Self-defense. If someone smashes your door in at 5 in the morning, you reach for your firearm to protect your family. In those seconds of confusion, you have an armed citizen and armed federal agents in a standoff that often ends in tragedy. Think about the reality of this for a law-abiding gun owner. You have trained, you have invested in your tools, and you have a plan to protect your family from a home invasion. When the FBI smashes your door at dawn due to a GPS error, you don't see federal agents. You see unidentified intruders. In that moment, you reach for your firearm. This is what I call the self-defense trap. If you defend your home against what you reasonably believe is a violent home invasion, and those intruders turn out to be federal agents who made a mistake, the government's first move has traditionally been to hide behind immunity. If the government can hide behind immunity every time they pull a GPS error, there is zero incentive for them to be careful. There is zero incentive for them to double-check the address before they pull the pin on a flashbang. This Supreme Court ruling is a massive step toward accountability. It tells federal agencies that if you mess up, you pay. You don't get to hide behind the Constitution to avoid the consequences of your negligence. Now let me connect this to the second massive case, because these two rulings work together to create a complete picture of how the Supreme Court is reining in government overreach. While the Martin case deals with what happens when the government physically violates your rights through wrong house raids, the second case deals with what happens when the government tries to rewrite the law to turn you into a criminal overnight. Many of you might remember the case about bump stocks. After the tragic shooting in Las Vegas in 2017, there was enormous political pressure to do something about bump stocks. Now, bump stocks are devices that use the recoil energy of a semi-automatic firearm to assist in rapid firing. They don't actually convert a gun into a machine gun mechanically, but they do allow for faster firing. Here's where things get interesting. For years, the ATF, the Bureau of Alcohol, Tobacco, Firearms and Explosives, had consistently ruled that bump stocks were legal. They had examined them multiple times under multiple administrations, and every single time they concluded that bump stocks did not meet the legal definition of a machine gun under federal law. But then, after the Las Vegas shooting, the political winds shifted. The Trump administration directed the ATF to take another look at bump stocks. And suddenly, without Congress passing any new law, without any legislative debate, without any vote, the ATF reversed decades of their own precedent and declared that bump stocks were now machine guns and therefore illegal under the National Firearms Act. Anyone who owned one had to either destroy it or turn it in to the government. No compensation, no grandfathering, nothing. And if you failed to comply, you were now a federal felon facing up to 10 years in prison. Gun owner Michael Cargill, who owned a bump stock, challenged this rule. He argued that the ATF had overstepped its authority. He argued that the agency had essentially rewritten federal law without congressional approval. And he argued that if the government wanted to ban bump stocks, Congress needed to pass a law doing so. The ATF couldn't just wake up one day and decide to reinterpret the statute in a way that suddenly criminalized millions of Americans who had been acting legally the day before. When this case reached the Supreme Court, the court issued another 9-0 unanimous ruling. Let me say that again. 9-0 unanimous. Every single justice, from the most conservative to the most liberal, agreed on the outcome of this case. That almost never happens, especially on Second Amendment issues. The Supreme Court's opinion, written by Justice Clarence Thomas, was very clear. The court held that a bump stock does not convert a semi-automatic rifle into a machine gun as defined by federal law. The court looked at the text of the statute, which defines a machine gun as a weapon that fires automatically more than one shot, without manual reloading, by a single function of the trigger. The court found that with a bump stock, the trigger still has to be released and pulled again for each shot. The shooter's finger is still doing the work. It's just happening faster because the recoil is helping to reset the trigger. But that doesn't make it automatic fire, and it doesn't make it a machine gun under the law. Justice Thomas went even further. He wrote that if the ATF's interpretation were correct, then nearly every semi-automatic firearm could potentially be classified as a machine gun, depending on how you use it or what you attach to it. He pointed out that even something as simple as a rubber band or a belt loop could theoretically be used to achieve a similar effect as a bump stock. So, if the ATF's logic held, would those things also be machine guns? Would your finger be a machine gun? The court said this interpretation was absurd and that Congress simply didn't write the law that way. Now here's what connects these two cases and why they matter so much together. Both cases are fundamentally about the same thing: whether unelected federal bureaucrats get to operate above the law and without accountability. In the Martin case, the government tried to claim they were immune from being sued when they violated your rights. In the bump stock case, the government tried to claim they could rewrite criminal law without Congress. The Supreme Court shut down both attempts with unanimous decisions. This case wasn't really about bump stocks. This case was about something much bigger. This case was about whether unelected federal bureaucrats get to rewrite the law whenever it's politically convenient, or whether the elected representatives in Congress are the ones who make the laws. This case was about the limits of administrative power and whether agencies like the ATF can simply change their interpretation of a statute whenever they want, turning millions of law-abiding citizens into felons overnight. You see, what happened with bump stocks could happen with anything. It could happen with pistol braces. It could happen with certain types of ammunition. It could happen with magazine capacities. It could happen with any number of firearms accessories or components. If the ATF or any other federal agency has the power to simply reinterpret existing law without congressional approval, then no gun owner is safe. Because what's legal today could be illegal tomorrow, not because Congress passed a new law, but because some bureaucrat in Washington decided to read the old law differently. And that's exactly what the Supreme Court shut down in this 9-0 ruling. The court made it clear that agencies don't get to do that. The court made it clear that if the law doesn't say something, the agency can't just pretend it does. The court made it clear that the text of the statute is what matters, not what an agency wishes the statute said, not what would be politically popular, but what the law actually says. Now let's talk about the immediate and long-term impacts of these two rulings working together. First, the bump stock ban is now null and void. It's unenforceable. Anyone who was forced to destroy their bump stock or turn it into the government was deprived of their property without due process and without just compensation. Second, this ruling has massive implications for the ATF's pistol brace rule. The ATF recently issued a rule trying to reclassify millions of pistols with stabilizing braces as short-barreled rifles, which would require registration under the National Firearms Act. That rule is currently being challenged in multiple courts across the country. And guess what? Those courts now have a Supreme Court precedent that says the ATF can't just reinterpret the law to ban things that don't actually meet the statutory definition. Third, and this is where the Martin case comes back into play, these rulings impact every other alphabet agency that tries to do the same thing. The EPA, the FDA, the SEC, any federal agency that tries to stretch the meaning of a statute beyond what the text actually says is now on notice that the courts are going to push back. And when these agencies conduct enforcement actions like raids or seizures, they can no longer hide behind blanket immunity when they mess up. This is part of a broader trend we're seeing from the Supreme Court, where they're reining in what's called the administrative state. They're putting limits on how much power these unelected bureaucrats have to regulate our lives without congressional approval, and they're making it clear that when these agencies violate people's rights, there will be consequences. The Martin case ruling has massive downstream implications for other Second Amendment issues. Consider red flag laws or the ATF's knock and talk inspections. Often these actions are carried out based on thin evidence or administrative errors. If the government knows they can be held liable under state tort laws like assault, battery, or trespass because they no longer have that supremacy clause shield, they are going to be a lot more hesitant to engage in high-risk, low-information enforcement actions against gun owners. It levels the playing field. It reminds the feds that they are subject to the same laws as the private individuals they serve. Now, I want to be transparent with you. While the Supreme Court killed the Supremacy Clause defense in the Martin case, they did clarify that the discretionary function exception still exists. This means the battle is now shifting to a new front. The government will try to argue that every mistake is discretionary. But here is the silver lining. Justice Sotomayor, in her concurring opinion, signaled that the court is watching this closely. She highlighted that the exception should not shield careless conduct that doesn't involve legitimate policy judgments. For Second Amendment advocates, this is the opening we've been waiting for. We are moving toward a legal standard where "I didn't check the map" is no longer a valid excuse for violating a citizen's constitutional rights. Combined with the ruling that agencies can't just reinterpret laws to criminalize behavior, we now have a two-pronged protection. The government can't make up new crimes, and they can't escape accountability when they violate your rights enforcing the actual laws. Wrong classifications, mistaken interpretations, and overreaching regulations disproportionately impact law-abiding gun owners. These are people who are trying to follow the law. These are people who want to do the right thing. But when the rules keep changing, when what's legal one day becomes illegal the next, When agencies can arbitrarily decide to reclassify items that have been legal for years, it puts gun owners in an impossible position. And when these regulations go bad, especially when they're enforced through no-knock raids or aggressive tactics, people can get hurt. We've seen cases where gun owners have been arrested, prosecuted, and had their lives ruined because they possessed something that was legal when they bought it, but was later reclassified by some administrative rule change. And if the government can hide behind broad deference to agency interpretations every time they mess up, there's no accountability. There's no accountability for the agency, and there's no accountability for the individuals who made those decisions. These two Supreme Court rulings address both sides of that problem. Now let's talk about what happens next, because these cases are far from over in terms of their practical impact. In the Martin case, the Supreme Court's ruling was a vacate and remand order. This means they didn't just hand the Martin family a check for damages. Instead, they wiped out the bad 11th Circuit ruling and sent the case back down, telling the lower courts you used the wrong rules. Now go back and look at this case again without giving the government that unfair supremacy clause shield. You would think that after a 9-0 smackdown from the Supreme Court, the Department of Justice would admit they messed up and settle with this family. But that's not how the feds play. The DOJ has been doing everything in its power to stall. The 11th Circuit ordered the government to file a supplemental brief explaining how they could possibly justify their actions in light of the Supreme Court's new ruling. What did the DOJ do? They asked for an extension. They claimed that due to budgetary constraints and a potential government shutdown, they didn't have the resources to file their response on time. This is a classic war of attrition. The government has unlimited time and unlimited taxpayer money to fight you. They know that every month they delay is another month the Martin family has to pay for lawyers and deal with the trauma of that night without any resolution. They are hoping the family and the public will simply lose interest. But we're not going to let that happen. As for what happens with enforcement going forward, if the government wants to ban something, if they want to restrict your Second Amendment rights, if they want to regulate firearms or accessories, they have to go through Congress. They have to pass a law, they have to have a debate, they have to have a vote. They can't just have some ATF official sit in a back room and decide that the law suddenly means something it never meant before. And that's a huge win for gun owners. That's a huge win for constitutional rights in general, because the Second Amendment doesn't say the right to keep and bear arms shall not be infringed, unless a federal agency decides to reinterpret the law. It says shall not be infringed, period. And while there are legitimate debates about what types of regulations are constitutional, those debates need to happen in the open, in Congress, where the people's representatives can vote on them, and where the people can hold those representatives accountable at the ballot box. These rulings also have implications for how lower courts are going to interpret Second Amendment cases going forward. Remember, the Supreme Court has issued several major Second Amendment rulings in recent years. We had Heller, we had McDonald, we had Bruen. And in Bruen especially, the court made it clear that courts need to apply text, history, and tradition when analyzing Second Amendment cases. They can't just do a balancing test where they weigh the government's interest against the individual's rights. These new decisions reinforce that methodology. They reinforce that courts need to look at what the law actually says, not what someone wishes it said. They reinforce that we interpret statutes based on their text and their original meaning, not based on what seems like good policy today. And that's a methodology that favors gun rights and individual liberty across the board. The Martin case is a reminder that the Constitution is not a self-executing document. It requires brave people like the Martin family and Michael Cargill to stand up and say, no, you cannot do this to us. And it requires a judiciary that is willing to call out the government when it tries to invent its own immunity or rewrite laws on the fly. These 9-0 rulings are victories for the Fourth Amendment, safeguards for the Second Amendment, and massive warning shots to federal agencies that the era of broad immunity and unchecked administrative power is coming to an end. The DOJ can try to stall, they can file their supplemental briefs, and they can try to play word games with the lower courts. But the Supreme Court has already spoken. The wall is crumbling. As we get more information on how these cases develop, how Congress responds, and how federal agencies adapt their enforcement tactics, I will keep you updated every step of the way. If you found this breakdown helpful, please share this video. The mainstream media isn't talking about the technical details of these cases, but these details are exactly what determine whether or not you are safe in your own home and whether your rights are actually protected. Thank you so much for the support. Never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.